Welcome again to Introduction to Trademark Law. In this video, we're going to talk about functionality as another requisite for trademark protection. Now, let's go back a step. We have explained what is a trademark, the purpose of trademark law, which is to protect symbols, designs, devices used to differentiate products or services in the market. And we have explained that when someone acquires trademark rights, there is a monopoly on the use of certain device, symbol to differentiate products or services. Now, when we think about a trademark, we need the trademark to be distinctive enough so that a consumer may use that trademark to identify or distinguish one product from another. And it's also the kind of symbol that is effective to protect the goodwill of a company or a market participant. Basically, it's a device that is unique enough so that it builds the goodwill of this producer of a product or a service. That's the first part. Now, when we think about distinctiveness, we have talked about word marks, and we have explained that they should be fanciful or arbitrary. But that's not the only kind of trademarks that we may find. There is a concept of trade dress, which is similar to the term of trademark. So when we think in general about trademarks, we talk about symbols or devices used to distinguish a product from others or a service. Now, we may want to protect certain parts of the product. Maybe we place the mark here in front of the cup, or maybe we put it on the bottom. It depends. But sometimes what we want to protect maybe is the overall product appearance or how the product, its packaged, it's presented to the consumer. When we think about the overall appearance of a product or a service, we think about trade dress. Trade dress is the overall appearance of a product or a service which may be protected under trademark law. Now, once we have thought about distinctiveness, what kind of trademark we want to protect, it might be a word or it might be something else. It might be trade dress, the looks of a product or packaging or how I present a service. Then we think about the concept of functionality, because we need to draw the line between what is protected under trademark law and what is outside of the scope of trademark law and it might be protected under patent law. For instance, patent law protects inventions that are functional, that have application in the industry, that are non-obvious. So when we think about the functionality of a product, like the design of a product, we need to think, what are we exactly protecting and what is that feature or that product presentation doing in terms of the consumer and the product itself? With that in mind, let's talk about functionality as part of the analysis of trade dress protection as a form of a trademark, a device to distinguish products or services in the market, and whether functionality limits or not the protection of trade dress. Okay, so when we think of functionality, we think about a doctrine that is a typical concept applied to trade dress and that serves to prevent monopolization of useful features of a product and to protect consumers. There are certain features that are necessary for a product, maybe for the product to work properly, so the consumer needs those features to be used by different producers. Because remember, when we think about monopoly, it's not always desirable because monopoly may result in predatory prices and other uncompetitive conduct. The idea is then to use the functionality doctrine to understand what is protected and what is not protected under trademark law and to foster a healthy competition and innovation environment in the marketplace. And again, when we think about functionality, we think about the term of trade dress. Remember, the concept of trademark is very broad, so it will cover not only words, but also other symbols or devices, as long as those devices are used to distinguish a market participant or a person goods from others manufactured or sold by others. Now, when we think about functionality, there are two types of functionality. On one hand, we have utilitarian functionality, and to determine or evaluate that functionality, we apply what is called the Inwood test. This is a name that comes from certain cases, court cases, and there's going to be a step where maybe utilitarian functionality is not exactly what we need to evaluate. So we have also aesthetic functionality. So utilitarian functionality refers to two specific issues. When we think about the design of a product or the presentation of a service, we want to ask if that product design or product feature is essential for the use or purpose of that article, that good, or the provision of that service. And two, if that product design or feature or the presentation of a service actually affects the cost or the quality of that service or that article. Why is this? Because the selection of certain features for a product, it involves considerations of use or purpose, then that's not protected under trademark law. Or if the product design is related to cost or quality of a product, since we also want to protect consumers and we need certain features to protect healthy competition in the market, so products have certain standards of quality, then that specific feature is not protectable under trademark law. But it might be something about the product, the presentation of the product, that is not created for the purpose or for the use of that product, and it's not related to cost or quality. Maybe there's something else more than just making a product appealable to the consumer. So when we have that functionality, which does not exactly fit the definition of utilitarian functionality as a feature that is essential for the use or purpose of an article, or two, as a feature that affects the cost or the quality of an article, then we take a step further and we think about aesthetic functionality, the design of a product or a service, which also distinguish that product or a service, but it is necessary to maybe foster fair competition, maybe to protect consumers. Let's say it's a pill, it's a medicine. There are certain colors that we want to use in terms of a medicine to protect consumers so they can distinguish certain kinds of different medicines or pills. And when we think about aesthetic functionality, we think about this. Would protecting or allowing one market participant to appropriate that feature of a product or a service, would that right, that trademark right, hinder competitors significantly? Is this a feature of the product that is related to the reputation of that specific trademark claimant, or is this something that is non-reputation related and therefore giving that trademark right to only one market participant will actually disadvantage the market in general? So with that in mind, we're going to look to some cases. Now, the first case is Traffix Devices, Inc. versus Marketing Displays. In this case, it's interesting to note that there was a patent involved. The plaintiff in this case, Traffix Devices, was the owner of a patent for many years. However, the patent expired. The patent was for certain types of sign stand that was designed so when it was knocked down by wind or cars, it would just stand back. The patent expired, and after the patent term finished, the defendant manufactured its own sign. However, the plaintiff argued that the look or appearance of the original sign that was actually covered by patent rights was protected under trade secrets law. Therefore, the defendant was not allowed to create or manufacture a sign that looked similar to that product initially protected by Traffix Devices. And here the court noted, and this is what it's more important to highlight, is that the existence of a utility patent, it's a strong evidence that certain features or the presentation of a product or the way it is designed, those are indicative that those features are functional. And if those are functional, therefore they are out of the scope of protection of trademark law, which also means that patent law are rights granted for certain time. And once that term expires, that feature or product design or utility of a product, that becomes public domain. which means that others may now manufacture that product or that device, or they may manufacture similar products with similar designs. And the court explained that if we actually extend the term of that protection under the realm of trade dress, what we're doing is actually giving something that it's not granted by the law because patent rights have an expiration date. And once that's finished, then the product design or utility patent becomes public domain, and therefore other participants in the market may manufacture the same product. And the court was very emphatic in explaining that the Lanham Act was not created to reward manufacturers for innovation. That's within the realm of patent law. And once that period of exclusivity is finished, the plaintiff and any other plaintiffs may not prevent other market participants to manufacture their own version of the product. So when we think about utilitarian functionality, it's good to remember that these are the kind of questions we want to ask. Is it essential for the use or purpose of an article? Does it affect the cost or quality of an article? And maybe other considerations regarding industry-specific requirements or a standard for quality, or maybe what's more important for a product. And that's what we're going to see in the next case. So the next case is Groeneveld Transport Efficiency versus Louvercore Inter. And what you're seeing here on the screen, it's a device that is called a grease pump used to actually increase the operational efficiency of commercial trucks. It's interesting to know that this article was not actually seen by the end consumer, the beneficiary of a commercial truck. And in this case, the plaintiff wanted to protect in some way the overall design of its product. The issue was, in this case, whether a company may use trade dress law to protect a functional product design from a competitor, a copycat, who made a similar design, but there is no likelihood of confusion. So here the court noted that there was evidence of what were the considerations when Groeneveld designed its own grease pump. There was also consideration regarding the purpose of the product. And the purpose of the product was actually to improve the operational efficiency of lubrication systems in commercial trucks. So in this case, even though there were like alternative designs, the purpose of that specific design was to promote that efficiency, and others therefore were justified in using a design that was similar. Additionally, the court pointed out to the fact that first, trade dress does not require trademark registration or public registration before the USPTO, but the plaintiff must prove that the design is not functional. And in this case, the court noted the plaintiff did not meet its burden of proof. There was no evidence that that specific design was not functional. So the court explained that in this case, there was no protection for the plaintiff. Now let's talk about aesthetic functionality again. When we think about aesthetic functionality, we think about certain product features or the presentation of a service that are not related to the use or the purpose of the product, and that may not be related to cost or quality. That's one step of the analysis. The other part of the analysis that we need to make is that features of a product that are mainly ornamental, decoration, those are not entitled to protection under trademark law. And therefore, when we have something that is decoration or is merely ornamental, we don't even talk about functionality. We just conclude that that feature is not protected under trademark law. Now, we also want to consider the competitive advantages of that specific feature of a product, because remember, when we think about aesthetic functionality, we're doing an analysis of competition and the market, how the marketplace works. And we want to think, is this product feature related to the reputation of the claimant, or is non-reputational, and maybe allowing one market participant to actually appropriate that feature or a specific characteristic of a product is actually going to harm the marketplace and consumers in general. Now, the first case that I want to highlight is Wallace Intern Silversmiths Inc. versus Godinger Silver Art Co. And in this case, the plaintiff was a company that had been in the market for many, many years, like around 100 years. And they launched about 40 years before the lawsuit, certain silverware in a Baroque style. Specifically, this was called the Grand Baroque pattern for this silverware. Now, the company made this product, and years after, Godinger, the defendant, entered into the market of silverware and eventually launched its own silverware in Baroque style. However, according to the plaintiff, this was an infringement of the plaintiff's trade dress, and therefore the defendant was not entitled to manufacture this silverware in Baroque style. And the court explained that the way the plaintiff defined its trade dress was very broad. The plaintiff said that the Baroque, Grand Baroque pattern was the ornate, massive, flowery indented style, flowery roots, scrolls, curls. It was very broad in terms of what the plaintiff actually wanted to protect. So the court noted that first, in that specific market and that specific industry, there were actually other manufacturers and producers of silverware which also used that style, that Baroque style. Additionally, the court also noted that yes, the plaintiff's design was distinctive. However, that specific features of the product were not enough, and that similarity with the defendant were not enough to actually demonstrate a likelihood of consumer confusion. The court explained that even though the product design was similar, there were notable differences between them. And the court also noted that, again, the intended protection was too broad, saying Wallace protection is not for a precise expression of decorative style, but for basic elements of a style that is part of the public domain. So the court said, your language and your purpose is too broad. We will be harming the market if you're the only one allowed to actually manufacture or produce silverware in Baroque style. Therefore, the court sided with the defendant, and there was no protection for the plaintiff. And here, for instance, the court noticed that the decision was because the design elements were common in other silverware pattern and they were not unique specifically to Wallace. However, if Wallace wanted to protect, specific features of their product, it might be entitled to protection in regard to certain more specific design features of their Grand Baroque silverware. Now, when we think about trade dress, we also think about color and functionality. And the first thing we want to keep in mind is that in general, courts have recognized that color by itself may not work as a trademark with inherently distinctiveness, but color may function as a trademark if it has acquired distinctiveness, secondary meaning, a specific commercial impression in the mind of consumer. And this is because when we think about color, the first thing that naturally happens with consumers is that color is associated to making a product more appealing. Therefore, we have to find if that color has some other purpose besides making a product just beautiful. And I have here 3 examples of colors that have been protected as trademarks. We have Tiffany blue for the box with certain shade of blue that contains jewelry. And we have brown for UPS service. And we have also pink for T-Mobile. But remember that these rights have been granted after spending time and money in marketing efforts, in building an appearance before the consumer, in actually educating the consumer as to how the product or the service is presented. So remember, the color yields a utilitarian advantage, like yellow for safety or maybe red for certain warnings. Therefore, in general, the functionality doctrine bars trademark protection, but there is no per se rule regarding the protection of color as a trademark. It might get protection if it has acquired distinctiveness. And the first case, it's Qualitex versus Jacobson Products. And this is an important case because this is the case where we find the Qualitex test. So in this case, the court noted that there is no per se rule regarding color, that color may be as a descriptive mark in the sense that at first glance is not protectable because consumers not ordinarily think that color refers to the producer of a product, but they just think about the appeal of the product and how beautiful maybe the product is. However, the court noted that Qualitex was not defending green in general, but a specific shade of green as applied to pads that were sold to dry cleaning business for their use on dry cleaning presses. So there was a certain concrete and well-defined claim as to how green was going to be protected. Now, the court also noted in this case that the defendant argued that if we grant rights over green, there will be less colors available for market participants. And then the court said, well, yeah, it might be possible that once green is protected, the number of available colors is limited. However, if there is a point where the market will be harmed because other competitors or market participants cannot access, well, at that point, actually, the functionality doctrine is going to intervene and then color will not be any more protectable. However, that's just a hypothetical and it's not enough to deny protection to Qualitex. Then the defendant also referred to all cases where color had been denied protection. And again, the court said like, yes, but the protection of trademarks have changed and the Lanham Act has a very broad language. And if there is acquired distinctiveness or a secondary meaning or impression where color is related to the producer, not to a product specific, then it is entitled to protection. Now, another interesting case is in the world of fashion, Christian Louboutin versus Yves Saint Laurent. So in this case, Christian Louboutin filed a lawsuit against Yves Saint Laurent for the protection of its red sole in high heels, high fashion shoes. And Christian Louboutin has been in the market for a long time with its iconic red sole. And that's something that the court actually noticed, right? That Christian Louboutin was this high-end shoe designer renowned for his stylish stilettos with this signature lacquer red bottoms. And what happened later in time, Yves Saint Laurent announced that they were going to launch a monochromatic line of high heels. So one of those high heels was red with red soles. Now, in this case, the court decided whether color could be protected in a specific industry, the fashion industry, and whether it was protected in all instances or whether that protection was actually qualified. So the court noted, first of all, that an ornamental feature, as we have said, by itself, it's actually not protectable. If something is merely ornamental, it's actually outside of the scope of protection of trademark law, because an ornamental feature claim would significantly hinder competition in the fashion industry by limiting the range of adequate possibilities for designer. However, on the other hand, if color in some way has an arbitrary or distinctive significance, it's not mainly ornamental, and potential participants of the market may enter with their own version of the product and colors combined in a different way, then color is non-functional and therefore it might be entitled to protection under trademark law. And in this case, the court granted protection to Christian Louboutin, but not in all instances qualified. The protection will be granted to high heels or fashion high design shoes with red soles, where the sole, the bottom of the shoe, will be in contrast with the rest of the shoe. So shoes that were brown, black, blue, with red soles, those will be protected as trademark law, so as a trademark of Louis Vuitton, but not monochromatic shoes. So in this case, if Saint Laurent could produce its monochromatic red high heel, and there will be no trademark infringement. Additionally, here, Louis Vuitton had already actually registered his red color trademark before the USPTO. So as a result of this case, what happened is that the court ordered the USPTO to make more definite and more concrete, more narrow, the definition of what the Louis Vuitton trademark was. And the court considered to understand whether, in this case, color had acquired distinctiveness. The court considered things like the advertising expenditures, consumers' impression, unsolicited media coverage of a product, the sales success, the amount of use, the length of the use and exclusivity of the use, and also attempts to actually plagiarize the trademark. Okay, so again, when we think about trade dress, we think about the overall product design or packaging of a product, and we think about size, shape, texture, and graphics. But we also may be thinking about the way a service is presented. And that's why I bring you here some examples of trade dress that are protected. For instance, 3M product container of these earbuds. For hand sanitizer, this Olika design, and in this case, the USPTO actually first denied the protection of this trade dress, but the claimant explained that usually hand sanitizer is presented in a ordinary rectangular bottle. Therefore, this presentation of the product was actually quite unique. And of course, the classic Hershey's Kiss is another form of trade dress. Now, let's see the concept of trade dress when it comes to the presentation of services. Now, we have here the case 2 Pesos Incorporated versus Taco Cabana. And in this case, the plaintiff was Taco Cabana. And what happened is that they've been in the restaurant industry for a long time, and they had designed an iconic Mexican restaurant. The trade dress was defined as festive eating atmosphere, having interior dining and patio areas decorated with arty crafts, bright colors, paintings, and murals. Later in time, 2 Pesos opened its own restaurant, and the design and the atmosphere of the restaurant was similar. And what 2 Pesos argue was like, Taco Cabana is not entitled to protection because they must prove secondary meaning and a special commercial impression in the consumer before they're entitled to protection. So in this case, and for purposes of how a service is presented, the court explained that no, that's not actually accurate, because the overall presentation of a service, if it's non-functional, is inherently distinctive, and therefore there is no need to show a secondary meaning to be protected. The court explained that if we ask a plaintiff to wait in time until the overall design of or presentation of the service has acquired secondary meaning, in the meantime, what happens is that potential infringers are going to free ride from that design and may copy it and may enjoy the goodwill of the plaintiff. Therefore, in cases like this, when the overall presentation of a service is not functional, it's inherently distinctive, and therefore it's entitled to protection without secondary meaning evidence. Another interesting case is this one regarding product configuration. And here what we have, it's the design of baby clothing. Here it's Walmart stores versus Samara Brothers. So Samara Brothers made children clothes, and they were pretty famous. But what happened is that Walmart asked a designer to create clothing inspired by Samara Brothers. Samara Brothers find out and file a lawsuit against Walmart, arguing that they had copied their trade dress, and there was infringement in this case. In this case, additionally, those designs were not copyrighted, for instance, and were not also trademarked. And there was no trade dress registration before the USPTO. However, we know that trade dress does not need to be registered to be protected. So the focus would be on functional or not functional. And Samara Brothers argue that their designs have become well known and they were non-functional. It was just a product configuration that was unique enough to be entitled to protection. The court noted that the product design in this case was not distinctive enough. They considered the design of the product as a feature to make usually the product more appealing or useful, but not necessarily to identify the producer of a certain piece, in this case, a piece of clothing. Therefore, the party seeking protection, this means Samara Brothers, were required to present evidence that established the non-functionality of that product design. And in this case, the evidence was not enough to meet the burden of proof required from the plaintiffs. Therefore, the court sided with Walmart and there was no trade dress infringement. Now, we have also a case regarding the presentation of the product. So here we have the overall design or layout of a store which sells certain product. In this case, we were talking about wine, best sellers versus wine made simple. In this case, the issue was whether a wine made simple, the defendant had infringed upon bestseller trademark through the use of a similar store layout and design. And here, the court noted that maybe not all the elements of trade dress, of the presentation of a service or a product, are unique. There might be elements that actually are not unique, but that's not what actually makes trade dress entitled to protection. It's the combination of different elements, some more unique than others, that actually creates protection of trade dress under the trademark laws. And here the court specifically focused on the way those elements of the layout of best sellers were actually designed and combined, and said it's precisely these specific elements that comprise its distinct trade dress. So when the courts evaluate whether there is a certain layout or presentation of a product or a service that is entitled to protection, is that special and unique combination which actually merits the protection of the law. The court also noticed here that the evidence was not great on the part of the defendant. They were not really able to explain why they have come up with a similar design or layout for their stores. However, they explained that the plaintiff had met its burden of proof, explaining how the design of the store was not functional. It had no relationship to the quality of the wine, or it was not related to cost. It was not for purposes of like enjoying the consumer, the wine, anything like that. Therefore, it was inherently distinctive as a trade dress, and it was the overall combination of elements that was protecting the plaintiff. And therefore, the court also concluded that the law does not require that each and every element of trade dress be arbitrary or unique to grant protection. And finally, let's talk about some quite unique trademarks that are not very common, and this is smells and even sometimes flavors. The law has sometimes protected a smell or flavor, but this is very rare, especially because when we think about this, we also think about the functionality doctrine. Is that flavor or that smell actually necessary? Let's say we're selling candles or we're selling food. Well, maybe that smell or that flavor is just a consequence of how the product is built, what the product is, and is functional. So the instances where smell or flavor have been protected as trademarks are just few, and I have 3 examples here. Play-Doh, the smell of that malleable children's clay, it's protected. Verizon at some point filed for trademark registration of the smell of their stores, but the trademark so far as to the date of this course in 2024 has been deemed abandoned. And there is another example, these rose-scented marketing products that have been also protected buy registration before the USPTO because marketing products smelling well, there is no functionality there. It is not necessary for purposes of this service, and it is also not related to cost or to quality. Okay, so that was the topic of functionality. Please do your readings, complete the assignment, answer your quizzes, and leave any comments if you have questions. I will see you in the next chapter. Bye-bye. Mucho mejor.